Okay, Mr. Chair, the audio's fixed. You can restart.
Good morning. Welcome to the November 2020 meeting of the New York State Joint Commission on Public Ethics. Thanks to everyone for joining us today. As we have since the onset of the COVID pandemic, we will once again hold this meeting using video conferencing technology. The public session is accessible on Jacob's website to watch via live stream. As a reminder, it's important that only one person speak at a time. In addition, I ask that when you do speak, you identify yourself so that we have a clear record. We will take votes by a modified roll call to ensure that everyone is counted. Martin will call for votes in favor of a motion and record everyone he can see on the screen or in person. Remaining commissioners will be recorded by roll call. Please remember to mute your phone when you are not planning to speak. Thank you. Let's move to item 2 on the agenda, approval of the minutes from the October public session behind attachment A. Any questions or comments? Hearing none.
Move.
Thank you.
Second, Deering.
Thank you. Martin?
Yes, on the minutes, all in favor, please raise your hand. Okay, I see Deering, Whiteman.
Is everyone moving things around? Mute yourself if you're not speaking, please.
Commissioner Cohen.
Yes.
Hero.
Yes.
Jacob.
Yes.
Levine.
Yes.
McCarthy.
Yes.
12, motion passed.
Thank you. Item 3, report from staff.
Hi, we'll start, this is Monica Sam. We'll start with an outreach update. We plan to issue an ethics reminder in the next few weeks on using knowledge and expertise after leaving state employment in consideration of the post-employment restrictions. On December 10th, we're holding an ethics officer forum to discuss the public officers law implications for state agencies that have quote unquote embedded contractors who in some cases are located at the state offices performing the same work as state employees. And that, again, that's going to be held on December 10th for ethics officers. And we expect to issue our fall winter newsletter in December, hopefully before the next meeting of the commission. So that's outreach update. If there aren't any questions, I'll move on to our budget request. We received the call letter from the Division of Budget on about a few weeks ago, seeking that all agencies reduce their request by 5% from last year's appropriation. Our appropriation for fiscal year 2021 was $5.582 million. We submitted a request for fiscal year 21-22 for $5.302 million, reflecting that 5% reduction. It's a reduction of $279,100. We plan for this and can absorb the loss for next year. If there aren't any questions, I'll move on to just a brief update. As we've discussed, the commission has a committee that's been addressing questions related to confidentiality and records access review. The commission has, the committee reported to the full commission, and the commission has directed staff to move forward with the committee's proposal. Staff is preparing a revised rulemaking for its records access regulations to make more information available concerning financial disclosure statements, including that extensions are pending and that exemptions have been granted. Obviously not detailing anything related to the exemptions, but just that there are reductions or exemptions with the filing. Staff hopes to initiate the rulemaking at the December meeting during public session. In addition, staff is working to incorporate the committee's proposals relating to its investigations into its internal control procedures, and hopes to begin working those issues through with the commission in December during executive session, with the intention that the commission can publicly announce legal and policy determinations after it's made those determinations in executive session. The committee will continue to meet to address ongoing questions.
Any any comments, questions? Okay. Item 4, behind attachment B. Monica?
Yep, that'll be Carol Quinn.
Okay.
Carol, you're muted. Carol, you're muted.
Okay. Here we go. Now you can hear me?
Fine. Yep.
Okay, thanks.
ahead.
Karen Quinn. So the rulemakings you have before you are absolutely identical to the revised rulemakings that you approved at the October meeting. We're asking for an emergency adoption today on both of these rulemakings for 938 source of funding and 943 lobbying, in order for them to be in place for the next biennial period, which begins, which is 2021-22, beginning this January. This is just really to give proper notice to filers who will need to start filing. The new rules will be in effect for January 1st and cover lobbying activity in the 21-22 biennial period. So that's applicable to the 21-22 registrations, the bi-monthly reports that are due March 15th, and the client semi-annual reports that are due July 15th of 2021. The public comment period on the revised rulemaking will end December 25th, or really 26th. So we do expect to bring these rules back to you for formal permanent adoption, barring any substantial revisions. We're hoping that that will be in early 2021, possibly at the January commission meeting. But today we're seeking the emergency adoption of the same rules that you put forward for the revised rulemaking in order to have them in place and to give filers proper notice.
Any questions or comments? Okay, then I need separate motions for each of these. So let's start with the lobbying regs behind attachment B. Can I have a motion, please?
Moved. Commissioner Weitzman.
Thank you. Thank you. Martin?
On the lobbying regs, Part 943, all in favor, please raise your hand. I see all in Albany. I see 1, 2, 3, 4. Okay. I see Deering, Pfister, Weitzman, Horowitz, McNamara, Yates, and Rosen. Cohen,
Yes.
Shapiro,
Yes.
Jacob,
Yes.
Vine,
Yes.
McCarthy.
Yes.
12, motion carries.
Okay, and for the source of funding regs behind attachment C, can I have a motion there, please?
I'll move it. Deering. Weitzman.
Thank you. Thank you. Martin?
On Part 938, all in favor, please raise your hand. 1, 2, 3, 1, 2, 3, 4. I see Deering, Fisher, Weitzman, Horowitz, McNamara, Yates, and Rosen. Thank you. Cohen.
Yes.
Shapiro,
Yes.
Jacob,
Yes.
Vine,
Yes.
McCarthy.
Yes.
Yeah, that's 12, motion carries.
Okay, thank you. Item 5, under new and other business. Commissioner Yates, you have something you want to raise?
Sorry, had to unmute. Thank you. I prepared a resolution which is included in your packet along with some explanatory materials. Just to keep it short, in essence, the following. The executive law allows us to delegate certain matters to staff between meetings. The law is very clear that we cannot delegate to staff matters which require a vote of the commission. Back in 2012, a resolution was adopted. That was before that I was a member, but I have no complaint with that resolution. The resolution allowed staff to render informal advice if an affected person called for advice between meetings. And that's good. There's nothing in the statute that explicitly describes or or talks about informal advice, but as a practical matter, I think that's a good thing. The law and our regulations also provide for formal advice. The difference between formal advice and informal advice is consequential. If the commission votes on something and gives formal advice, then that's a bar to subsequent disciplinary actions or even criminal investigations. It's a complete cover. The law provides that those formal opinions may be published if they go to an executive official, must be published if they're given under the legislative law to a legislator or a candidate for the legislature. Unfortunately, just to continue a second, there are certain actions that under the law require commission approval. One of those is permission to engage in outside income for a public officer to draw in outside income or to engage in certain outside activities. So, for example, if a person's going to earn, a public officer is going to earn more than $5,000 of outside income, then they must get approval, not only from their employer, but also from the commission. That approval must come from the commission, not from a staff member. Now, the resolution that was adopted in 2012 is a good resolution. It allows for informal opinions by staff. It says nothing about issuing formal opinions, and it says nothing about giving the requisite approval for outside income or outside activities. Those matters are still left to the commission. Unfortunately, over time, a practice has evolved where from time to time, people looking to engage in outside activity or to draw outside income go ahead and ask for an informal opinion from the staff. So the question has arisen whether or not those informal opinions, A, are binding on the commission as though they had been formal opinions, and B, whether or not they constitute the approval that's required under the law to engage in that activity in the first place. I think the law is pretty clear that since we can't delegate those decisions to staff, that an informal opinion cannot constitute the approval by the commission of outside activity and does not constitute a formal opinion which would be published and which would be binding. However, I think there's a misapprehension by certain covered individuals that when they receive an informal opinion, that somehow or other they've met the requirement of getting approval, and that somehow or other that's binding cover or protection. So just to clear up any ambiguity so that people really understand what happens when they seek an informal opinion by staff, this resolution wouldn't change the authority that had been previously delegated, but it would be notice to the public that, yes, you can seek an informal opinion as you did in the past, but it's not going to be binding, and it's not a formal approval, and it's not a formal advisory opinion. And even more so, tied into that is the fact that not on every occasion has the commission itself or all the commissioners been advised of the informal opinions that were given. So somehow or other, at the very least, the commissioners ought to know about the informal opinions, and the commissioners should fulfill their responsibility of either approving or disapproving outside income or activities when it's required, and also elect to either publish or not publish, as the law provides, the formal advisory opinion that's given, if it is given. So I have in the packet, and you've seen, and I'm not going to restate it word for word, basically that it is the old resolution, and it says The old resolution's fine, but if there's an informal advisory opinion given, then the person should be advised that it does not constitute the formal approval that's required under the law, and it is not a formal opinion which is binding on the commission. I make that as a motion. I don't know if anyone wants to second it or not.
Before we get there, let's ask if there's any comment from any of the other commissioners.
Well, if I may, Mr. Chairman, can I ask a few questions of our staff?
Yep, go ahead.
I want to make sure I understand what the current practice is per the 2012 resolution. And if I'm parsing this in a way that is not accurate, please bring me up short right away. Number one, on an outside activity request that is made by a constitutional officer, which is to say one of the 4 statewide elected officers, or an agency head of a department, are those being granted without a vote of the commission?
That is correct. The practice of staff under the delegation as it's been interpreted by this commission since 2012, and this delegation is nearly identical to the delegation in 2007, and that was the practice in the Commission on Public Integrity. And it's my understanding this was also the practice under the State Ethics Commission. Staff handled outside activity requests as part of the informal guidance that was delegated to staff, and no votes of the commission were required. So that's been the practice for my entire experience at JCO.
All right, let me now move to a request to participate in some activity that results in income other than state employment exceeding $5,000. Is the application for income activity subsumed within the process to approve outside activity, or is that a separate consideration and disposition?
Our interpretation and our predecessor to interpretation was that the approval outside activity was treated the same as all other informal guidance. I'm not sure if that's your question. And the regulations require commission approval, the same language for all policymakers who engage in income over outside activities with income over $5,000, as well as some other things. So the outside activity regs require commission approval for both policymakers and, as you say, the constitutional officers and the agency heads. It's in 932.5A and B.
Yes. So my follow-up question to the general counsel is it staff's position that approvals for outside income activity can be disposed of informally by staff the same way that a generic outside activity request will be disposed of? In other words, the commission is not involved.
Yes, it's staff's position. It's also been the position of all of the prior commissioners and prior staff of our agency and our predecessors. There's been no distinction made between agency heads and constitutional officers and other policymakers. And the language in the regs doesn't really just make the distinction between them. Both are subject to commission approval. The only distinction is that you need also the approval of your appointing authority. And so for the case of the constitutional officers and the agency heads, since they're the head, the commission is the only entity that approves those activities. But this remains within the discretion of the commission. The commission can change the delegation, but it's always been the interpretation of the delegation to include that authority as part of the delegation of informal guidance to staff.
Am I right that we voted on this last time in the last hearing, correct?
Yes,
I don't
Change the delegation.
think so. I respectfully disagree.
Can I finish?
Yeah.
Let me finish. Thank you. Did we or did we not vote, Monica, last meeting on changing the delegation authority, and did we not fail to pass that motion to change last time? Yes or no?
yes, there was a motion about the delegation at the last meeting and it did not carry.
May I be heard on that?
Yeah, please.
Thank you.
Well, if I may, Mr.
I-
Chairman.
If I can be heard on that, Gary.
One at a time. Gary, I may have cut you off, so if I did, I apologize. Why don't you finish, Commissioner Yates? You'll go after that.
I certainly want to hear what everyone has to say, but I just want to understand what the current practice is to set the basis for the ensuing discussion. I'll redirect to our general counsel. Is it the current practice, I gather it's the current practice, that informal opinions are issued by the staff without the deliberation and approval of the commission, and in some instances, the commissioners may not even be notified that the opinion was rendered. Is that the case? Although you keep a log of them. Do I understand all of that correctly?
Right. The practice has been that we handle informal. There's a log available. If commissions ask questions, they've had access to the log. We currently give you the log for the officials that you've asked to see the log for. And these have been handled by staff. However, as you know, certain high-profile matters have been brought to the commission's attention when staff is considering them. But the staff has had the authority, and that's how it's been interpreted, to resolve those and provide the guidance. That's been the practice, again, here for my entire time here since 2012, and it is my understanding that's the Commission on Public Integrity and the State Ethics Commission handled it the same way.
Now, with respect to so-called formal written opinions, is it staff's position those in the current practice protocol must be deliberated upon by the commission and approved by a vote of the commission?
By a vote of, I didn't hear what you said, by a vote of 8, that has been this commission's practice. The commission and our predecessors have always reserved the power to do advisory opinions. They've only delegated to staff informal guidance. So formal advisory opinions will require a vote and are posted on the commission's website in a redacted form.
Now, with respect to the categories that you've enumerated of informal action by the staff, or stated another way, action by the staff without deliberation and approval by the commissioners, would be outside activities subsumed within that, would be requests to earn income above $5,000 and also informal opinions. Have I summarized this correctly?
Yes, I think so. I'm just not sure if all it's informal. Staff has provided guidance, what we call informal guidance, which includes approval of outside activities as well as honorarium in some cases, travel, and other guidance under our regulations. Staff has done that without consulting the commission in most instances. And as I mentioned, we do bring certain high-profile matters to the commission's attention routinely.
Now, I want to draw attention to the phrase without consultation with the commission. Nonetheless, though, is there been on occasion consultation with respect to the rendering of informal action or action by the staff with individual commissioners?
We brought them to the attention of the entire commission, with the exception of one matter in which I was not involved. Based on the delegation of authority, the chair was involved and I was not involved. But other than that, we bring the matter to the attention of the full commission, like I mentioned, with respect to certain high-profile matters.
Right, but for example, with regard to requests from policymakers, whether it's a constitutional officer or an agency head or some other designated policy makers, the staff would render an action without full commission consultation or formal approval. But my question is, has there been occasion within the last 36 months in which staff has taken an action with a consultation with one or more commissioners individually?
I'm not sure I understand your question. You know, with the exception of the one matter in which you're familiar that I was not involved and the chair was, we don't normally consult with commissioners with respect to our routine guidance that we provide. When we brought it to the attention of the commissioners, we've had discussions with many commissioners, including you, about those issues. We've gotten emails from commissioners about those issues that we brought to the full commission's attention. But that's been dependent on which commissioners sort of bring it up with us. But we notify the full commission when we have those issues. Otherwise, the commission tends not to be involved with the informal guidance that we provide on a regular basis.
Well, before we get to the motion in chief, on this fellow traveling matter, Mr. Chairman, if I may express myself, I, of all people, who have availed myself to great edifying effect with informal discussion with their staff, they're always professional and always acute. I'm actually a strong advocate of commissioners having informal consultation with the staff on any matter. And with respect to the chair, I believe it is desirable and actually necessary that there be a consultation with you on all sensitive matters. There is no question about your integrity, and I've said it behind your back, which is the sincerest form of compliment. Nonetheless, though, I want to say on this particular subset of the discussion, Mr. Chairman, if a policymaker asks for an opinion, assuming that the judge's motion doesn't prevail, and we continue with this approach where the staff is taking action without the commissioners, if there is a consultation on one of these actions by staff with an individual commissioner, that the full commission be notified. Thank you for letting me take a few moments.
Yeah, no problem. And Commissioner Yates will come to you in 1 second, but let me just respond to that. First of all, Gary, thank you as always for the compliment. I'm happy to accept it, not behind my back, but directly face to face. And I appreciate that. Secondly, to the extent that, and I want to be clear about my own personal view here, to the extent that the commission wants to revisit the delegation of authority that has been in place for many years, whether in a limited fashion or in a more broad brush fashion, I'm perfectly willing to engage in those discussions. I think we should do it in executive session, and when and if we come to a conclusion, we can determine whether it's appropriate to bring it to public attention. Nevertheless, we have in front of us something put forward by Commissioner Yates, and I'm not attempting to put words in your mouth here, Commissioner. I believe my view is that we have already voted on this and we have failed to pass it, but please do give me your interpretation, please.
Yeah, thank you. I would like to address that. First of all, the matter was raised without any analysis, background, or information last time. It was raised it was a different motion. It was a motion by Commissioner Levine that was limited only to outside activity requests by the 4 statewide elected officials and agency heads. It didn't address the broader matter that that my motion addresses, which is the delegation of authority generally, and notice to the public what's delegated and what's not delegated. So they're different motions. That's number one. Number two, I included in the packet and gave everybody at least a week's notice of all the background information that wasn't available last time. Number three, the maker of the motion last time, at first, it wasn't even a motion. The person who raised it was Gary Levine, Commissioner Levine, and he himself, when it was clear that we didn't have all the information we needed, withdrew and asked for, his motion was for more information and for discussion at the next meeting, this meeting. However, notwithstanding that, a member or two of the commission went ahead, knowing and even announcing that they were against the idea of amending the regulation or dealing with Commissioner Levine's motion, which was confined to the elected statewide officials, went ahead and made the same motion. And if you look at the minutes, which we just approved, the motion that was made by Commissioner Fisher and seconded by Commissioner Horowitz, both of whom were clear that they intended to make a motion and then vote against it, went ahead and said that the motion was to require that outside activity requests from the 4 statewide elected officials and agency heads be brought to the commission for a vote. That's not the same as my motion. And then the vote, by the way, was 6-6. And I think we all know that a 6-6 vote is not dispositive or binding or precedential in any way. So my motion is different. It's broader. It's with the background information we didn't have last time, which Commissioner Levine sought but was unable to obtain during that meeting. And it was a different motion, and the vote was 6-6, so it's not binding. And then finally, I really sincerely hope that nobody would suggest that merely because we had an uninformed and incomplete discussion last time, and then a motion made by people who did not want to amend the resolution that failed 6-6, that somehow or other that binds us in perpetuity from ever looking at whether or not people are apprehending the current authority that exists under the existing 2012 regulation. And lastly, the thing that I've got is that I must point out is our counsel has on several occasions today said that this was always the interpretation. I'm sorry, but I've only been on the commission since for 3 or 4 years, not ever since 2012, but I never ever remember there ever being a discussion where the commissioners approved this, either implicitly or explicitly. It may be that it was always staff's interpretation that they had more authority than they really do have, but it was never the commission's discussed and approved decision that staff had more authority than I believe they're entitled to.
Thank you. So let me say a couple of things and then I'll open it up to everybody else here. I received your request to put this on the public agenda and agreed to do so, which is why we're here talking about it. So any suggestion that I or anybody else is attempting to stifle your motion is absurd on its face.
Okay, good.
A. B. I do not. So when you move this, I am telling you now that I will vote against it, not because I am not willing to entertain a commission discussion of, and if it carries by the necessary number of votes, a revision of the delegation of authority that it's been in place for many years, but because I do not accept on its face your assertions of what the law says and doesn't say. Not because I don't think that your voice is to be respected. To the contrary, Commissioner Yates, I have the utmost regard for you and your views on what the law, especially in this area, says and doesn't say. Having said that, we know full well that, since most of us here are lawyers, that what law actually says is in the eye of the finder of fact. And you are, I believe, in your resolution, quite adamant about stating what you believe the law to state, which I don't agree with you on. I don't think the law says what you say it says, and I respect your interpretation of it, but that is all that it is. Because you speak about it forcefully doesn't make it more valid than if you spoke about it less forcefully, or frankly, whether anybody else spoke about their own interpretations of the law, whether consistent with or corollary to or against your own interpretation thereof. So because I do not accept your interpretation of the law, and because I don't think that what you proposed is in the functioning commission's best interest, I will vote against it once it's moved, which I expect that it will be. But I want to reiterate that I am not opposed to taking up a discussion in executive session with the commission on whether we should, and if so, to what extent, alter the delegation of authority. Anybody else want to be heard on this?
I do want, just as a point of order, I guess, I was not leveling any criticism at you. I think you do a terrific job as chair, and I thank you for putting this on the public session agenda the way I asked. What I was responding to forcefully, if that's the word you want to use, was the assertion that somehow or other last month's vote precluded consideration of this motion. Thank you.
Okay. Commissioner, it's hard for me to see. There I see some hands, but maybe if you can give me as to who is. I see Commissioner McNamara directly in front of me, Commissioner Horowitz. I think Commissioner Fisher also had hands up. Is there anybody else who I'm not recognizing who wants to be heard? All right, so Commissioner McNamara, go ahead. You can go first.
Okay, thank you, Chair. So I don't desire to revisit the delegation as I understand its limits. I'm just more interested in knowing whether staff is observing its limits. So as I understand it, we receive a request for approval of outside activities, and then the staff, pursuant to the delegation, responds to that request for approval of outside activities. And within the limits of the delegation, the response to that request for approval has to come in the form of informal guidance. And it has to come in the form of informal guidance based upon prior precedents. They can't create the guidance from whole cloth. There has to be some guidance to support it. And my question is really one of process. So when the staff responds to the request for approval in the form of informal guidance, does the response indicate that it is informal guidance? Does it indicate that it's being issued pursuant to the delegation of authority to issue informal guidance? And is there any disclaimer about the extent of the effect of that informal guidance with respect to approval of outside activities?
So, Commissioner, I'll try and answer your questions. Staff fully understands the limits of its delegation, and with respect to informal guidance, is very careful to make sure that if it is giving guidance, that it is relying on precedent and bringing to the attention of the commission any matters that are unprecedented. As I mentioned at the last commission meeting, over the course of the history of this agency and its predecessors, many of these questions have been addressed or have created a model by which, an analytical model by which to answer the questions. So staff follows that. We have an ethics division, an attorneys in that division, and they handle these requests daily. And we have the Attorney of the Day program in which they do so. And they have discussions and review these review our guidance, they look at our advisory opinions, and they give guidance based on what our precedent says. We don't make a distinction in how we handle outside activity requests from other forms of guidance. In our practice, we treat them all the same. We are looking for whether or not there's a prior precedent on point and applying that precedent to the request. The guidance that we give does have some disclaimers. As we discussed with the commission over the years, we now make it very clear that when it's an informal opinion, it is said that this is staff's opinion. There are limitations that are made clear that we are relying on the representations that are made by the individuals requesting the guidance. And if it turns out that those representations are not accurate, then the guidance cannot be used as some kind of a defense if we were to pursue an enforcement action. So there are some limitations, and there are some language in there. If the commission would like to take a look at some of those letters and wants to work with staff on revising some of that language, that would be helpful, and we'd be open to that. The language in the letters has evolved. As I said, we've recently made changes at the commission's request to make it very clear when that it's staff that's issuing the guidance, and that is limited to the individual who's making the request, because the informal guidance is not public and is not posted on the website. So a lot of that is in there, but again, we're open to submitting some of these letters, some of them more recent letters to the commission for review, and you could help us, edit and revise the standard language however you see fit. It does not reference the delegation. That has not been part of the practice of this commission. If that's something the commission wants us to conclude, we're happy to include that. And again, any other edits or revisions the commission wants.
Mm-hmm. Thank you, Monica. I would just suggest to the commission that staff develop a template for rendering informal guidance that includes specific reference to the fact that it's guidance that's being issued pursuant to the delegation, reference the limits of the effect of that guidance, and that to me should resolve the issue. It's really a matter of what the legal effect of the informal guidance is.
Thank you, Commissioner. Commissioner Fisher?
So what I wanted to say at this point in the discussion is that I agree with Commissioner Yates that his motion is different than my motion from the last meeting. I think mine was very specific to an action that Commissioner Levine recommended, which would apply the changes that we would make only to outside activity approval requests made by the 4 statewide elected officials and department heads. So that's more narrow and different than what Commissioner Yates has put forward and that we've had a chance to review in advance of this meeting. So that's all I want to say at this point, but I would like the opportunity, if and when Commissioner Yates' motion is seconded, to have a period of debate, and at that point I would like to state my views on whether to adopt this resolution or not.
Okay, thank you. Commissioner Horwitz.
Thanks, Mr. Chairman. My apologies to everybody. My audio and video isn't great today, so if there's feedback or a problem, please tell me. So, I appreciate I appreciate the thoughtfulness and care in which you've taken this issue up, which is not it certainly is in keeping with the way you approach all these issues. As the chair said, many of us are lawyers, and we do look at the law, and often we agree, and often we have and sometimes we have a different view of what the law requires. And in this case, I happen to agree with the chair. So I think that there are 2 things or 3 things that I think that are important, especially because we're having this discussion, and appropriately so, in the public session. The first is one, I think, for the broader public to understand, that in the 30 years that the commission and its predecessors have been following the practice that we're discussing today, which is and we touched on this in our meeting last month, to dispense informal advice to, anybody in who holds a public office in the state to call up and seek informal advice. Often I think our staff gets calls about questions about what happens when people are preparing to leave the government and what the rules are. So I think one of the things that's very important here is, and I think Commissioner Yates, you touched on it, is that to the extent that the staff is speaking and dispensing advice about the public officers law and our ethics laws, that advice is not a cover and has never been a cover to our commission and any predecessor agencies' ability to enforce violations of the law. And what I mean by that is, and we have, and I don't remember whether or not you were a member of the commission, but in my time on the commission, I can think of at least 2 instances where the commission ended up bringing enforcement actions because the state employee or the state public official either didn't fully disclose information to the staff when they sought advice, or they twisted it and tried to use and twist the advice, the proper advice that was given, as a defense to a violation of the public officers law. And the commission rightfully did not stand for that, and we ended up successfully prosecuting enforcement claims against those public officers for the informal advice that's been given. And unfortunately, it doesn't happen very often. Unfortunately, frankly, it shouldn't happen at all, but it does happen. But I think the message I think we need to think about is that the way that the commission and its predecessor agencies have approached the issue of informal advice doesn't mean that we are somehow we are left without the ability to prosecute violations of the public officers law. So that's the first point I wanted to make. The second point I want to make is really just more informational, because I think, as you said, Commissioner Yates, we did have, a somewhat attenuated discussion about this. There was a colloquy with the staff. Some of the commissioners were asking questions. The staff, I think, did their best to answer, as they always do. And I think, everybody's had a chance to reflect. But, I think that, there are, some additional considerations that we touched on that bear comment, today. One is what I've already said, which is that, the commission and its predecessor agencies have been following this practice of the staff giving informal advice, dating back to 1989. That's number one. Number two, there are a tremendous number of people who rely on that advice. And if to the extent that commissioners like Commissioner McNamara, believes that, we should see the criteria, the formal criteria that we follow in giving the advice out, and whatever questions or caveats are provided, I don't think that, I think that's a good suggestion, but I do think that the staff, follows a protocol, and I think they follow a protocol, listening to what the advice that's being sought is what that advice is, what is the question. They give thought to what that answer should be based on the commission's precedent on the law, and I think, as we've heard, there's a process for documenting what the questions are and how they're responded to. And as I think a number of people alluded to today, at least in some instances, particularly in the higher profile ones, many commissioners, are aware of those requests and have, as Commissioner Fine said, a healthy discussion with the staff about what's been going on. So there's no, if you would, hiding the ball in that respect. And then I think the last point that I want to make is, and forgive me because this may be a little bit in the weeds, but to the extent Mr. Yates, has raised the question about the legal authority for the staff to dispense informal advice because of, an interpretation I believe he has it in good faith, of our laws, particularly 9416. There are a number of instances where, to follow Commissioner Yates's logic to its conclusion, if the statute is to be read the way Commissioner Yates wants to read it, then we, the commissioners, would have to do the following things. We would have to provide ethics trainings program. We would have to provide notices of if we fail to file their financial disclosure forms and notices of system, the other things that we've delegated to the staff, where, Commissioner, under your interpretation of the law, because there isn't an explicit delegation provision, the staff wouldn't be able to engage in that. So, and I don't mean to make light, of the Commissioner proposal or even your interpretation, but I do want to point out that there is basis in the law for our delegation to the staff of dispensing informal advice. So, again, thank you for indulging me for a few minutes. I welcome the discussion, and unfortunately, Commissioner Yates, I'm not going to support this motion if you get a second, because in all candor, I think our staff and the staff that we've had before does a terrific job of handling requests for outside advice from any member of the public employee. Thank you, Mr. Chairman.
Commissioner Deering.
I want to add to some comments that I had made the last time too. I think one thing that's important with regard to the request is the speed with which the staff responds to them. So I think a couple things. The track record of the staff in terms of addressing these issues has been outstanding and very remarkable. I think that from what I've seen over time as a member of the commission and then previously as the general counsel of a state agency, the JCOPE staff is incredibly thorough with regard to their analyses. And what I've seen also is they take very seriously looking back on past precedent. And I think their analysis really is outstanding. And I think that from the standpoint of public officers, whether it's a statewide elected official or whether it's an individual who's been designated a policymaker, one thing that's key is that not only do they get thoughtful, thorough advice, but also that they get it on a timely basis. And I think that if we were to change the process whereby the commission, in essence, took over the work that's currently being performed by staff, I think a few things would happen. Number one, we just don't have the expertise that the staff do. We would be relying upon their expertise. We would be taking on a full-time job, I think, and I just don't see I don't see a reason to change what's been working very
well. Mike, this is Rob Cohen. Can I just chime in, and I just want to add on to what Jim said.
Go ahead.
As a former staff member, I just want to say that if staff had to rely, or if the commission had to approve every single piece of written guidance that comes out of the commission that the staff would normally send out, it would things would come to a halt. And quite frankly, and I can assure you that people would simply, there'd be no reason to seek advice from the commission, because as Commissioner Deering so rightly pointed out, it would just take too long. And so I think the law here, notwithstanding Commissioner Yates' own view of it, the law here is, and what I believe the interpretation of the law is one that actually works in reality. and one that acknowledges the reality of the commission's role and the staff's role and the public's need to get timely responses. And I don't want to put staff on the spot here, but I'm just wondering if anyone on staff has some general sense of how many written pieces of what we're calling informal guidance are put out each year, whether it's outside activity requests, informal opinions, travel, honoraria. Does the staff have, I apologize for not asking staff to maybe get those numbers before this meeting, but if you just had some general sense of how many pieces of written guidance are put out each year, I think it might be helpful so some commissioners get a sense of the workload that we're talking about.
Sure. I mean, Keith or Michael, you should jump in if you have them handy. My understanding is that staff, handles roughly, 40 plus informals per month in a typical month. And we report on this in the annual report and break it down by how many outside activities and how many other types of guidance that staff has issued. But does that sound about right, Keith, Michael? It's about 40 or so a month?
40 or 50. I mean, I'd say, give or take a few, but around 50 a month, easily.
If I may, Mr. Chair.
Thank you. So you're talking about 500 written pieces of 500 written pieces of guidance that right now do not require a formal action by the commission, that under a different interpretation might require that. And I just think that's a formula. That's just a different way. That's just a way to hamstring the commission, and it would nullify, I think, a lot of the good the commission does in providing advice and guidance to people who want to do the right thing, and they come to us wanting to do the right thing and seeking guidance to do the right thing, and most people want that guidance in a timely and efficient way because they need to move on with their lives and live their lives and do what they need to do for themselves and still abide by the public officers law. And with that, I'll go back on mute.
And I might add, this is Keith St. John, with respect to the 50 or so a month of requests for guidance, again, that's really limited to just the state officers, the 4 electeds, statewide electeds, and agency heads. When we factor in the rest of our population, the policymakers, then we're well in excess of probably 100 a month in total requests for guidance.
Thank you. Thank you very much.
Commissioner Yates.
Yeah, unfortunately, I think the last 3 speakers or commissioners who spoke addressed an issue which is not addressed by my motion. I said at the beginning, and I'll repeat it again, that we had previously delegated the authority to make informal advisory opinions, and it's a good thing, and I want to keep it. And even though the statute's not explicit about language about that, and Commissioner Horowitz somehow or other has turned that into an argument that I'm against informal advice. I'm not. The old delegation allowed informal advice. As Commissioner Rosen pointed out, informal advice is a good thing. But my motion, if you read it carefully, it does not take away the ability to give informal advice. What it does is very similar to what Commissioner McNamara and Commissioner Horowitz earlier said they would like to do. And that's why I'm not sure why if they oppose the motion, why they would. All my motion does is it says, keep the practice that you have, but when you give advice, advise people, tell them that it's informal advice. It doesn't constitute the formal advice that would be written and voted upon by the commission. And that it is informal advice, so that it's a caveat emptor. So the person who gets that advice knows that they're receiving informal advice, but not a commission formal opinion. And in that regard, I'd like to ask staff a question. And that is, Since for me, the distinction, and I think the law is clear that there's a difference between informal advice and formal advice, is it staff's position, A, that if informal advice is given, that's binding upon the commission later on, even if a majority of the commissioners disagree. And B, the statute's very clear that we can publish advisory opinions. Is it the staff's position that if they give approval, that the commission is powerless to publicize or even know about the opinions?
So, Commissioner Yates, I actually think your first question is a really good one. We talked about it briefly at the last commission meeting, and I think that this is the source of a lot of confusion. So, but just can I just ask one question, because the draft delegation that you provided seems to take away the delegation for staff to give guidance on outside activities and outside activity approvals. Is that what you intend in your delegation? Because that's how it looks to me. So if we could clarify that.
Once again, and I can't say this, I can't repeat it enough. In my mind, there's a difference between informal advice and approval and formal advice and approval. And formal advice or approval is required. It can't be delegated away by the commission because it requires a vote of the commission. And going back to Commissioner Levine's earlier point, I think what aggravates this situation is that the commission's not only not taking a vote on the informal advice, but is not even aware of it in most instances. So I think that means at the end of the day that the distinction between formal and informal advice needs to be clear, and that someone who receives the advice should know that they're receiving informal advice.
Okay, so if I understand, it sounds like you're on the bottom of the first page of your delegation, you're just trying to distinguish between formal and informal, and not trying to say that staff can't give informal guidance on outside activities. So
I think staff should give informal advice. I think staff should give informal advice, and they should let the consumer know that it's informal staff advice.
So then one of your questions was about whether or not staff's informal guidance is binding on the commission. And as we discussed at the last meeting, I think that the commission could reverse staff if it chose to do so. I think what the commission needs to discuss is what that actually practically would mean, because when staff gives informal guidance, people rely on it and take steps and measures. And so the commission could conclude that staff reached the wrong conclusion, and that something, for example, would be a conflict, or that a gift would be a violation of the law. But the gift has probably already been accepted. The trip has probably already been taken. The employee may have already left state service or accepted a job in state service in reliance on staff guidance. So when we talk about that the commission isn't bound, I think it would be helpful if you can talk about what that means to you in terms of what, if the commission reverses staff after staff has relied on the decision, what's the import, what's the impact on the individual who has requested the guidance? Are you saying they can't then have a defense? I think that would be helpful to talk through.
Okay, I'm very glad to answer staff's question, and I will, and then I'll go back and once again ask staff to answer my question. So first I'll answer your question, and that is, enough of us are attorneys here to know that if you advise, that anyone who relied upon that advice, especially if it's based on precedent, would have a very, very, very good defense if anyone were to raise it, either here in the commission or in any other setting. We all know that good faith reliance upon advice by one of the staff members here would be almost tantamount to a defense absent other factors, such as the staff being really wrong or having been misadvised. I go back to the question I asked you, which unfortunately I either didn't hear the answer or you didn't answer, and that is, take for instance, if there were an informal bit of advice that had been given in the last year. If the commission looked at it and thought, that that was wrong, or even if the commission thought that it was right, but wanted to publish it, is the commission divested of its authority to either correct an opinion that's wrong or divested of the option it has under the law of publishing an opinion?
No, I don't think that the commission is divested of that ability, but it has to be done in a way that protects the confidentiality. So the practice under 9416 has always been that when the commission gives guidance, even when it's formal, it redacts the names of the requester and any identifying information, and so it's presented as a generic advisory opinion. And that's the way that the commission has done that. So I think the commission can always, clarify a legal issue, issue an advisory opinion that takes a position on a legal issue. That's what the commission's done for years.
So then that goes back to Commissioner Levine's earlier point, and that is, if there are some opinions that have been given in the last, I think he said 36 months, I don't know, whatever time period was important to the other commissioners, then there's no problem with us taking a vote to publish them with subject to redaction, because that's an option that we have under the law.
Well, I think if the commission was going to issue a new advisory opinion, that's how it would do it. So it wouldn't take the staff decision and make it public. It would write the new advisory opinion stating the position the commission wants to take and make that public. That's, the commission has to vote on the opinion and issue it. And so that's how that would be. What's been in practice is, for example, we recently had this, where staff gave advice, and this is something that they're advised of in the informal guidance. If they don't agree with staff interpretation, then they can seek an advisory opinion. So the commission has tended to, it has tended to rely on the individual to seek an advisory opinion rather than to and to take an opinion that comes in and make it a formal advisory opinion. It's usually been at the request of the individual. Do we want the commission to weigh in? And that way the individual has the option of withdrawing their request or bringing it to the commission. So whenever we get something, for example, that would implicate the full commission, people understand that it's going to be a public opinion.
Chairman? Mr. Chairman?
Yes.
I just want to respond briefly to some of the comments that Commissioner Yates has raised about his motion.
Please.
I mean, I think one of the things that helps about, sort of what is underscoring this discussion is this, it seems to be implicit that somehow that the advice that our professional staff, and I underline, underscore, put in bold letters the word professional, because these are men and women who spend every day dealing with public ethics, the public officers law. They are experts. That's why they work for us. We some of us, I think all of us, make a very good faith effort to try to make sure we understand, the staff that we deal with. But the staff deals with these issues every single day. And to the extent that we delegate, as we must, because as Commissioner Deering and Commissioner Cohen pointed out, we can't spend all of our time on Jacob. That's why we have a staff. So to the extent that we're asking questions about how our staff carries out a function that, based on what Keith was saying, we deal with every day, and our staff and the staff before this staff for 30 years has been dealing with these issues. So one thing I think that bothers me a little bit, that somehow, despite, again, people say that they like our staff and they have great respect for them, but yet in this particular instance, we're scratching our heads saying to ourselves, well, gee, we're really not sure about the advice that our staff is dispensing. So we need to have, a new procedure. And I'm not sure one is called for, number one. Number two, and as I said before, I don't have any problem with the staff explaining to us as Commissioner Rosen said in executive session, what the factors are, how they go about their due diligence and dispense advice. That would be, I think, a helpful discussion to have. So that's my first point. The second point is that we operate with the idea that people should want to come to us and ask us for advice. We want to encourage the people who work in the state to call our staff and say, you know, I've got a situation and I'm not really sure what to do or what the law is. I'm leaving, or my cousin got a job, you know, another agency, or I've seen something that is bothering me, that one of my coworkers is engaging. We want to encourage people to come forward. And if we get into a situation where somebody calls up and asks for advice, I'm thinking of taking a job, and I am thinking about working for this particular company. What are the rules about, you know, leaving service and appearing in front of the state again, or appearing in front of my agency again? I mean, and if our staff has to go through all of that, and at the end we give some disclaimer, oh, by the way, if you screw it up, or even though I'm telling you what I believe the law is, the commission can still come after you. You know, when that gets out, how will we have a drop off in people seeking our advice? And I come back to the point I made, you know, earlier, which is that we can and have prosecuted people for violations of the public officers law even after they've gotten advice from the staff. One, we always have that authority. If the staff get it wrong, and I don't think they do, but if they get it wrong, we can go after somebody, notwithstanding whether the defense be, you know, rock solid or not. Number one. Number two, the likely scenario, and the one that we've encountered, is when the wrongdoer takes advice and either withholds information from the staff and doesn't tell them the full story, or they lie and the staff is not aware of those misrepresentations and gives advice. And that's the circumstance that's more likely to come up. And Commissioner Yates, you know, from your experience, you know, as a practicing litigator and from sitting on the bench, you know full well that under those circumstances, mounting a defense of reliance becomes far more complicated when the defendant has withheld or lied about information. So I am not as concerned as you are about what the impact of somebody relying on advice from staff will mean about our ability to enforce the public officers law. So again, I respect the spirit in which you are making your motion. I still remain unpersuaded that this is something that we do memorialize with your motion, and I'm going to continue to oppose. Thank you, Mr. Chairman.
Okay, does anybody else want to be heard on this?
Yeah, Mike, this is Rob Cohen. Just very briefly,
Go ahead, Rob.
if I may.
Yep.
I just want to make it clear to some of the commissioners who might be new here that Commissioner Yates seems to be making a distinction between outside activity requests and advisory opinions, but there's no ontological difference there. They're both, an outside activity request is an informal advisory opinion that is interpreting aspects of the public officer law and commission precedents. It is that's what an informal advisory opinion is. It's a outside activity request is just a subset of, it is a type of informal advisory opinion. So there's nothing unique about these outside activity requests within the realm of advisory opinions generally. We have just decided they're given that name because outside activity requests tend to group around a kind of similar sets of facts and a similar analyses. But it's you know, we have post-employment outside activity requests. You know, they're not treated any different than any other outside activity request just because they deal with the post-employment restrictions in the public officers law. So outside activity requests are informal guidance like any other informal guidance. They're no different. That's just a point I want to make for everyone's consideration.
Thank you. Commissioner Weissman?
Thank you very much, Mr. Chair. As maybe the person who inadvertently started this when he asked the question and the questions got rebuffed, I went down the rabbit hole this month. I looked at 22 months of activity in the log. That runs between 75 to 100 requests for information per month. So what's that? 1,700 to about 2,200. I can tell you that staff does an excellent job. I can tell you that in only one instance would we question a staff result, and I think there were maybe 4 or 5 others that we would just ask questions on, but that may be because the log doesn't contain enough information. Having said that, my view in looking at Commissioner Yates's resolution was to take it in not necessarily a step further, but for staff to provide the commission with its determinations every month, and we would effectively approve it on as a consent calendar, because based on what I went through, we're not going to have a lot of questions. And at the end of the day, that may ultimately give the subjects, you know, whether or not we wanted to tell them that the commission approved it would be something different, and we could discuss that. But we are not required to publish anything. It's a may. And that's how I view Commissioner Yates's proposal and taking it the next step.
Thank you. Commissioner Deering?
No, I'm set, thanks.
Okay. Anybody else? All right, Commissioner Yates, go ahead and move your proposal.
All right. I'll move the proposal. I think one good point has been raised during the discussion. And if my language is unclear, I reiterate what its intent was, and I would even entertain a modification. My intent was to continue the practice of informal opinions, to continue the practice of allowing people in good faith to rely on them, but for people to be advised that an informal opinion is not a formal opinion, and to recognize the distinction between a formal opinion and an informal, and to make it clear that the commission still reserves the right to exercise its option to publicize an opinion and to override a staff opinion. That's the intent. And if the language is not clear enough, I'll entertain a motion to alter it, but that was the intent of and I think what's written in the motion.
Thank you. Is there a second?
Second.
Okay, Martin?
Before we vote, could we have a period of debate? I'd like to state my...
Yep, please, go ahead.
So I plan to vote against this resolution, and there's 2 reasons, and I'd like to explain them to my fellow commissioners. First of all, I don't believe that, and this is probably quibbling, but the 4th whereas clause is, I don't believe, accurate about what Executive Law Section 94.6 says. So as I read that section, and I'm not a lawyer, but as I read it, it states a power of our commission. It does not state a requirement. But this whereas clause asserts that this section requires us to act by majority vote. And maybe that's the past practice, and maybe that's the precedent, but I don't believe that that section of the statute requires us to vote in order to render a formal opinion. in response to a request for one. My second reason for planning to vote against this is the language of the resolution, which I believe goes too far. The underline in section 1 of the resolution, provided, however, that such advice shall not constitute an advisory opinion as authorized by the executive law or legislative law. That all seems fine to me, but what comes next, I think, is not supported by what the statute says. And what this resolution says is, in the absence of a majority vote by the commission in a written opinion endorsing such advice, and shall not be binding upon the commission. I think the practical effect of that language is going to be, no one's ever going to ask us for an informal opinion. Because if you have language that says, shall not be binding on the commission, it almost says, don't listen to this informal opinion because it can't be trusted. We stand ready to reverse ourselves or reverse our staff. So it renders that pretty close to useless. So for those reasons, I don't believe that the statute says what the whereas clause says, and I believe that there will be a negative impact on our staff of the specific language in the resolution, in the resolve clause, in the section 1 that changes that amends paragraph 16 of resolution 1202.
Thank you. Any other comments?
On the motion, Mr. Chairman,
Yes.
all of the discussion about the statute is very edifying. Let me address it in terms of principle being propounded by the statute. I cannot accept the fundamental proposition that the statute contemplates a permanent abrogation of the commissioner's authority to approve outside activity by the 4 constitutional officers and agency heads. Therefore, I am strongly in favor of the resolution.
Thank you. Other comments?
May I? Yes, one more, at least.
Yeah.
Marvin here.
Yeah, go ahead, Marvin.
I think we've, with all respect, the resolution or the motion seeks to pry these things apart. But I've asked this of staff, and I ask them again. The resolution of 2012 carries forward the language of the statute in paragraph 16, provided such delegation is in writing and the specific powers to be delegated are enumerated. So I was there in 2012, as were several other commissioners. The powers that are enumerated in the resolution of 2012 is one power: to render informal opinions or render opinions between meetings based on precedent. There is another statute, and that's paragraph 17. 17 deals with honoraria, gifts, outside income, outside activity. That section is likewise set forth in our resolution of December. But nowhere in that resolution do we say that the powers of the commission enumerated, section 17, are delegated to the staff. Now, that may be upsetting to people on the staff, but when a statute requires that the specific powers that are to be delegated be enumerated in the delegation, and you have a general statement about opinions between meetings, as Commissioner Levine says, he's going to vote against this because the notion that we delegated everything in section 17 when nothing has been enumerated in the delegation involving Section 17, and this is a pure question of law. I recognize there are people who can differ with me, but I'm just reading the statute. There are two paragraphs, 16 and 17. Our delegation dealt with 16 advisory opinions. Our delegation never mentioned anything that is in 17 as being delegated. And I've asked this of staff. I ask them again. If the specific powers to be delegated are to be enumerated, and that is a statutory mandate and a statement in our delegations of 2012, where in that delegation have we ever delegated anything in Section 17 involving outside activity and outside income? I would ask that of Martin. I'd ask it of Monica.
So, Commissioner, my answer to you, I don't think it's going to resolve your question, but is that this commission and our predecessors have interpreted informal guidance, these informal letters, to cover all the forms of guidance of the commission. The outside activity regulations date back to 1990, and they've been changed over the years, but they date back that far. And the commission and its staff and its predecessors have interpreted the delegation of informal guidance in 9416 to cover all the forms of guidance, not just outside activities, but honoraria, travel, interpretation and application of the public service announcement regulations, which the commission issued. 17 authorizes the commission to issue regulations. 9416 authorizes the commission to give guidance. And it's under 9416 that the commission delegated the authority to staff to give informal guidance. And again, it's just been interpreted to cover all of the guidance. If the commission wants to specify the various different types of legal questions the commission is going to delegate to staff to address, the commission can do so. But it's through the power to issue guidance that the staff answers those questions.
Thank you for your answer, Monica. I respect your answer. It is a staff interpretation. And that's what I heard on the phone before this meeting from another staff member. But since it is a staff interpretation of a statute, what Commissioner Yates and Levine are dealing with is let's codify this a little better, maybe even beyond what is before us today. Let's specify much better so people who seek our informal guidance, your informal guidance, understand that what they get is valid, but it's informal. But I can't interpret these statutes, and I can't conflate them as you do. One deals with advisory opinions, the other deals with entirely different actions of this commission. Those were never delegated. And that is my position, and I will vote for Commissioner Yates' motion.
Thank you, Commissioner. Anybody else? All right, Martin, I think we're at the roll call stage.
On the motion to amend the delegation as described in the materials provided by Commissioner Yates, all in favor, please raise your hand. I see Commissioners Weissman, McNamara, and Yates in favor. Have I missed anyone?
Jacob.
I apologize. Well, I didn't see you.
You didn't call. I'm sorry. I'm sorry. My hand doesn't appear through the phone.
Okay. So I will call the roll for the remaining commissioners. Commissioner Deering.
No.
Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Commissioner Cohen.
No.
Commissioner DePiro.
No.
Commissioner Jacob, you indicated you were voting in favor.
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
and Chair Rosen.
No.
That is 1, 2, 3, 4, 5, 6 in favor and 6 opposed. Motion fails.
Okay.
Mr. Chairman.
Yes. Yes.
I have a motion.
Commissioner Levine,
I have a motion.
go.
May I?
Please.
I move that all informal opinions rendered by staff with respect to outside activity within the last 36 months, the constitutional officers or agency heads be put into the public domain immediately.
Is there a second to that motion?
May I ask a question?
Of course.
Can we do that? General Counsel, can we do that?
I don't believe we can. You can't make something that is confidential public. We've discussed this. This is going to continue the debate about whether or not confidentiality applies. I understand that. And Commissioner Yates asked me questions relating to this earlier, but the statute says when someone requests a formal advisory opinion, and so I think this is a question the Commission could discuss, and it has legal implications.
Well, look, we have a confidentiality committee where we can take this issue up. And then, Gary, if you're willing to withdraw your motion, we can revisit it once we've had a chance to talk about whether or not we can actually do that, even if there were enough votes in favor of doing that. But that's up to you if you want to press forward with the motion or not.
Yes, I will withdraw the motion, but I'm exiting for today. I want to observe we now have a practice in which staff is rendering the opinions. The commissioners are not being consulted generally, let alone deliberating and voting. And now we have that we can't put these informal opinions rendered by staff into the public domain. I believe this is the worst of every aspect of the circumstance, but I will withdraw the motion on your representation, Mr. Chairman.
Okay.
Mr. Chair.
Yes, go ahead.
Go
ahead, Commissioner Yates.
I don't think this requires a formal motion, but I just want to raise it as a consequence of this stymied vote. Our website, under the Attorney of the Day section, says that the Attorney of the Day renders opinions both formal and informal. I don't think we need a motion on this. I'm asking staff or whoever set up the website to strike the word formal from that because it's just the wrong advice.
We'll take care of that.
Okay. Anything else that anybody wants to raise before we move into executive session?
Mr. Chairman, it's Commissioner DePiero. If I could ask one question.
Yes, of course. Go ahead, Commissioner.
I apologize. Number one, I'm not an attorney, and number two, I'm one of the newer members of the commission. But when we get notified, commission members get notified of a recommendation by staff relative to outside income. Does that afford us individually or collectively the right to have an opinion about that? And if we have an opinion and forward it, does staff take that under consideration? Or by the time we're notified, is it already a done deal?
So, Commissioner DePiero, I just want to clarify, most informal guidance that staff provides is done without notifying the commission. The commission, of course, could always ask to see the log, but again, on a daily basis, we're giving out that informal guidance. When staff
it's only for the fourth statewide?
It's not even, it hasn't always been every matter because some of them are de minimis or not very material. But when we do bring it to the commission's attention, of course, we're seeking commission guidance, there's an opportunity for the commission to ask questions. Commissioners, nearly half the commissioners have given us their view on some of these matters or have asked for additional information, not just about outside activities, which has happened, you know, from time to time over the last 8 years that we've come to the commission about outside activity requests, but over the past 8 years, we've also come on other issues that we've brought to the commission's attention. And so, of course, when the commissioners, you know, give us their thoughts or recommendations, we take that into consideration. Staff spends a lot of time, you know, looking at the guidance and trying to apply it and raising the issues and asking for more information.
Right. Thank you for the clarification.
Okay. I heard somebody else.
Mr. Chairman.
Yeah, Gary, go ahead.
The last two meetings, there's been a discussion regarding the executive order exempting so-called volunteers assisting the executive chamber in responding to the public health emergency from the provisions of the Public Officers Law. The request was made to ascertain from the executive chamber who has been exempted within the ambit of the executive order. Do we have a response from the executive chamber?
So, Commissioner Levine, just to clarify, what I was directed to ask was whether they have a process to keep track of that information. And I have relayed that request, and I received a response, and their question is, you know, they're considering the commission's request, and they want to know under what legal authority the commission is requesting this information.
Mr. Chairman, if I may, it's now obvious that the executive chamber does not wish to divulge this information. In the last discussion we've had for an hour, one of the arguments in favor of the proposition that action in responding to the constitutional officers would be timeliness of a response. But the obverse is obviously not true when we make an inquiry.
Okay.
I have a follow-up question to Monica on that.
Mm-hmm.
Sure.
If there's an obvious conflict of interest that we see in the actions of a volunteer, someone who is self-dealing, giving themselves a contract worth $1 million without any kind of basis, if that's happening, and if a person complains to the commission, do you interpret the executive order as precluding us from having the ability to investigate whether that complaint about an obvious conflict of interest?
No, I don't. And as with any matter, one of the first steps when we get a complaint is that we would ask the commission to authorize us to have communications, and we would want to have the authority to speak to the chamber to find out whether or not they had given guidance to this volunteer, or if their agency had given guidance to this volunteer. And, you know, under the executive order, the commission would have to also make a separate independent determination, regardless of the executive order, you know, volunteers typically aren't covered by the Public Officers Law. So we would have to consider that. So I think there's always a lot of questions when we have an actual case that's in front of us. And it just because an individual is not subject to the Public Officers Law certainly doesn't mean that there might not be other laws that might apply to their conduct that other agencies can also enforce. So I think the problem will be if someone is determined to be covered by the executive order, whether or not the Public Officers Law can be applied to them. And I think the answer to that would probably be no. But again, I'd have to see the specific facts and circumstances, and we'd have to understand what, if any, guidance that individual had been given about the application of the executive order.
Anybody else? All right. Can I have a motion to enter into executive session, please?
I'll move. Hearing.
Thank you.
DePiero,
Second. Thank
DePiero,
you,
second.
Martin. Thank you,
Move on.
Commissioner.
On the motion to move into executive session, all in favor, please raise your hand. I see Deering, Fisher, Weissman, Horowitz, McNamara, Yates, and Rosen. Commissioner Cohen,
Yes.
Hero,
Yes.
Jacob,
Yes.
Levine, Carthy.
Yes.
Motion carries.
Thank you.
Stand by. All right, Mr. Chair, we're back in public session.
Great, thanks. And Monica, can you please summarize what we discussed in executive session?
Sure. We discussed litigation matters and legal issues pertaining to financial disclosure statements. We granted an application for exemption from the post-employment restrictions pursuant to Public Officers Law 73-8-B. And we authorized steps in several investigative matters, closed one matter, and discussed several other investigative matters.
Great, thanks. Unless there's something else, is there a motion to adjourn?
Moved.
So moved.
Commissioners Weissman and DePiero.
On the motion to adjourn, all in favor, please raise your hand.
Aye.
5, I see Commissioners Deering, Fisher, Weissman, Horowitz, and Yates. Cohen,
Yes.
Hero,
Yes.
Jacob,
Yes.
Levine,
Yes.
Carthy.
Yes.
Motion carries.
Great. Have a great Thanksgiving.
Happy Thanksgiving.
Take care.
Everything.